Greetings, Goeiemorgen, Molweni. As we commemorate the 2020 International Translation Day, the Pan-South African Language Board, a constitutional body mandated to safeguard the development, the use, the promotion, the preservation, and the linguistic rights of all South African citizens, acknowledges the great work of both the international and the South African professional translators and interpreters. Their impeccable skill of finding words to resolve crises in various spheres of life, inclusive of access to the justice system, bridging the gap between the literate, illiterate, and within any other forms of language barriers through the word. This indeed is in line with this year's theme of the International Translation Day, finding the words for a world in crisis. We acknowledge and humbly appreciate the new terminology developed during the COVID-19 pandemic to send the message to the masses in the languages they understand, the 12 official languages and the South African Sign Language. We are looking forward to the speakers of today's seminar, and we want to live by example through the use of our languages. The call in the South African Constitution preamble, acknowledging the injustices of the past. We believe in the justice system of South Africa, and we believe that the use of all South African languages open doors for all South Africans to access the system equally and fairly. Yes, we believe that the use of all official languages in all platforms of government enables access to information to each and every South African, which is a linguistic right. Happy International Translation Day. Enkosi. Thank you.
Good morning, everyone. Molweni. I have been entrusted with the task of introducing ELAF, which stands for Indigenous Languages Action Forum. ELAF was launched in February 2019 and is an organization made up of academics, language practitioners, representatives of NGOs, and language activists. Our mission is to develop the full use of all of South Africa's indigenous languages in all sectors of public life, but particularly in high-impact domains such as education, healthcare, social welfare, and the law, especially the criminal justice system, which is the theme for our webinar today. ILAF believes that it is only in the full development and use of our indigenous languages that we can build a stable and human rights-oriented democracy. I would now like to introduce Natasha Joseph, who is the discussion leader for today's webinar. Natasha is a South African editor and journalist with 15 years' experience. She completed a degree in journalism at the university currently known as Rhodes in 2003, and then embarked on a journalism career which took her from the Cape Times newspaper as a reporter to the Cape Argus and later City Press as a news editor. In 2015, she was part of the team that launched The Conversation Africa, and earlier this year, she left that organization to become a full-time freelancer. She has been published all over the world, including in the Index on Censorship magazine, The Atlantic, and Al Jazeera English. Welcome, Natasha.
Thank you very much, Professor Ramani, for that introduction, and welcome everybody to today's webinar, co-hosted by the Indigenous Languages Action Forum and the Pan-South African Languages Board of the Western Cape. We're very pleased to have everybody here and hope that everybody had a great Heritage Day yesterday. Of course, it's still Heritage Month for a few more days, and today's topic, language in the criminal justice system. Well, of course, language intimately intertwined with heritage, so very topical for this moment in time. We'll be looking at the role that language plays in courtrooms and in other criminal justice settings, like in police stations. We're very pleased to be joined by three excellent speakers today to kick the discussion off with their insights. And we'll then be moving on to about 40 to 45 minutes of open discussion and debate. We're opening up for questions from the floor, or whatever it is that one calls the room in a Zoom webinar in these strange new times of ours. So just to talk you through what we'll be doing, we'll have three speakers whom I'll introduce in a moment, and then we'll move on to the debate and discussion portion before wrapping up. So thank you all again for signing on and joining us today. We have three speakers, as I said, and I'll introduce them in the order that they will be addressing us. Speaking first is retired Constitutional Court Justice Johan Krichler, who served on the Constitutional Court bench from 1994 to 2002. But while he may have retired from the Constitutional Court, he remains extremely active, particularly in the academic sector, and remains extremely involved around the justice system. Our second speaker is Professor Monwabisi Kgalagala. He's the Dean of the Faculty of Arts at the University of the Western Cape. And then wrapping things up will be Dr. Zakira Dokrat, a postdoctoral fellow at Rhodes University who specializes in forensic linguistics. We're set up for a really good, insightful set of discussions and presentations, and we hope that you'll enjoy them. Let's start things off by going over to Justice Johan Krichler.
Good morning, Natasha. Good morning, Monwabisi. Good morning, Zakira, and to the viewers. Great privilege to be able to participate in this discussion. Let me, however, start with just a disclaimer. I am no academic. I am no specialist in linguistics. I am a lawyer. I'm not even a jurist. I am, however, an experienced practicing lawyer. I have several years in the courts of the country, and I think I know perfectly well how they work. Let me also say, by way of introduction, that there is no debate about the constitutional provisions protecting and promoting the interests of marginalized peoples, minorities of all kinds, particular language and cultural minorities. It's fundamental to the Constitution in any event, but the Constitution in the Bill of Rights, Section 30, 31, 35, 36, specifically protect the interests of any of our 11 languages. Section 30 expressly protects the right to use the language of your choice in all interchanges with the state. To participate in cultural life is protected by Section 32. The Constitution is express in its recognition. And this is understandable because we know what the history was, and the Constitution, as it expressly says, is a bridge to the future, and a recognition of the dignity of each individual requires the respect for the individual to use her or his mother tongue or language of choice. That's not in dispute. What we are looking at in essence, however, is purely at the use of language of choice within the forensic context. The questions posed are, in effect, what are the advantages and what are the disadvantages relatively between the use of English as the i.e. the only language of record in court, the only language used and is which used to record the proceedings, or on the other hand, the right of an individual to have the proceedings proceed and be recorded in any one of the 11 official languages at the choice of the accused person. The balance between advantages and disadvantages of the two in court context is what we're talking about. A subsidiary question, as posed, the third question, is it practical or practicable to have an unlimited choice of language of record in court proceedings, i.e. is one at liberty to say, I wish these proceedings to be conducted in language X or Y or Z. Right. There is no doubt at all that in terms of section 35 of the Constitution, an accused person is entitled to understand the proceedings and to have the proceedings proceed in the language that that person understands, or to be to a language that that person understands. Now, does one do that in terms of a procedure? I see the internet tells me that the connection is unstable at the moment. I will nevertheless proceed unless I am stopped. The problem is that the language of choice of the accused person is not necessarily the language with which the other participants in the process are proficient. We know that we have a multicultural country, a multicultural environment. It may be that in certain isolated instances in remote rural areas, a particular language is used by all concerned, but it's most unlikely in any of the urban areas. Thus, for instance, if we take Gauteng in Johannesburg, you would easily find within a social circle, a random one of 10 or 12 people, 4 or 5 indigenous languages being the home languages of the people. So in the courtroom in Johannesburg, you could well have the magistrate who's English speaking, the prosecutor who's Xhosa speaking, the witness who is Zulu speaking, and the accused who is Tswana speaking. Which one of those do you then use? You use Tswana. Is the magistrate proficient? Is the prosecutor proficient? Can the court proceedings continue if they are not proficient? The problem also is that in our system, which is an adversary court system, the language used by the legal representatives is crucial. Both the prosecution and the defense have a vital role to play. They engage in dialogue with one another. The presiding officer in the role of a referee must equally be proficient in the language of that debate. Neither of them necessarily shares a mother tongue with the accused person himself. For the defense counsel to be able to defend adequately, competently, there has to be a communication, a real communication between counsel and the accused person. that requires proficiency by the representative in the language of the accused person. But the representative is a professional who represents accused A today and accused B tomorrow and accused C the next day. They may each have a different home language. Does that then postulate that the practitioner must be proficient, sufficiently proficient, and that is a high level of proficiency to communicate fully, adequately, perceptively, nuanced perception of the communications of each one of those clients? It's a counsel of perfection, I'm afraid. It will not be possible. Likewise, the police in a given police station should be able, theoretically, to record any statement made by any person, a complainant or an accused person, in the language of choice of that person. No police station in the country can be conducted on the basis that it has at all times a person capable of recording a statement in any one of the 11 official languages. It simply can't work like that. The unfortunate truth is that you simply have to choose a language and be capable of converting by interpretation any language into that particular language. Or one or two or maybe three at the outside. Otherwise, the system simply cannot function. We know that our statutes are drafted in English. We know that our textbooks are written in English. We know that our court cases and our judicially created law is largely in English. There is no hierarchy of language other than English available for the recording of the common law, of the statute law, and of the case law, or of the textbooks. Unfortunately, unless and until you have a library available in which all of the cases and all of the statutes and all of the law reports are recorded, you will simply have to choose one. I suggest to you that on the basis of practicability, on the basis of practicality, on the basis of sheer functional necessity, we have no choice. For me personally, it's an uncomfortable choice. I'm not happy with it. English is not my mother tongue. I am particularly passionate about my language. It used to be a language of record. I think it was a highly developed technical language for use in court. I was most unhappy when it was abandoned, but I saw the necessity. You simply cannot have court cases being conducted in Afrikaans when you thereby exclude practitioners, judges of any group which is not proficient in Afrikaans. I must make this point that you may be able to conduct a case in Sannieshof in Afrikaans, where the magistrate is Afrikaans and the complainant is Afrikaans and the prosecutor is Afrikaans and the accused is Afrikaans and the local defense attorney is Afrikaans speaking. But when that case has been determined and there is an appeal, that appeal must go to Pretoria, where you have judges, various kinds of language and cultural background. You cannot have special judges to deal with cases coming from magistracies where the language was Afrikaans and somewhere they come from Venda, and the language is Chavenda, or from Mambatu, and the language is Tswana. You simply have to pick one language which is commonly used by all. And we know that English is used by only about 8% of the population as a mother tongue. But we also know that the majority of people who come into contact with officialdom, who are likely to be in court, are proficient to some extent in English. And we also know that we have a body of interpreters that is capable of translating from any of the indigenous languages into English. To sum up, therefore, I would suggest to you that we have no choice. It's an unhappy choice, but it's one that's forced upon us. English must be used as the language of record in all proceedings in courts in South Africa. The Chief Justice, in making the ruling 2 or 3 years ago, took a difficult and painful decision. It cannot please everybody, but I believe that anybody who's serious about the administration of justice must accept that it was the only possible arrangement. Thank you.
Thank you very much, Justice Krichle. Some really important points to kick things off today. Moving on to our second speaker, again from the University of the Western Cape, Professor Monwabisi Kgalagala. Over to you.
Greetings, everybody. I'd like to address a very interesting topic, that is language and justice. And my topic is going to be based on a very interesting observation. In 2017, April 16, we picked up from the media that English will remain the only language of record in South Africa. This pronouncement, which I believe came from the office of the Chief Justice, did not only create a stir amongst ordinary South Africans. For some of us who are involved in language matters, as linguists, as activists, it had some grave implications. Now, those implications could mean access to justice, for example, the promotion and protection of indigenous languages, if you like. You could think broadly about linguistic human rights. And this also, to a certain point, affected other sectors, not only the criminal justice system. You could think of higher education as an example, and basic education. Now, there were interesting reactions by South Africans. Perhaps we might want to take a moment and hear what they have to say.
It doesn't make sense that in a country with 11 official languages, we would only use firstly a European language to translate judgments that are that important. I mean, constitutional court judgments affect almost everyone everywhere in the country, and the layman needs to be able to get it in their own mother tongue.
The problem is a valid one, but the response could be debated. On the one hand, I agree that precisely because of the various languages used in the country, especially as mother tongues, it poses potential obstacles in terms of access to justice, already on top of the materialist obstacles towards accessing that justice. But I think other alternatives must be sought in order to help overcome these obstacles.
The Honourable Chief Justice does appear to have a point in respect of the pragmatic effect. It would then begin to make sense to one that court officials, i.e. presiding officers, magistrates, judges, and chief justices or justices of the Constitutional Court are learned people. Most of them have received their course content, the lecturing thereof, in English, or they are verily able to understand English. whether or not it is their mother tongue. So therefore, in an attempt to tighten the purse strings, if you like, I am apt to agree with the Chief Justice in this regard.
As much as I understand where he's coming from, I also think it's unfair, and it would actually make all of these cases inaccessible to those who would want them but cannot read English. I think it creates a lot of how can I put this? I think it creates a lot of problems down the line for those who can't read English. I mean, if they can have translators translating in courts, then it should be easy for them to also transcribe those cases in the mother language it was at least presented in.
Prosecutors and judges send innocent people to jail because of that language barrier. And then now when he talks about a language which is understood by all, as if it's trying to make the situation fair, it's highly unfair, because at the end of the day, the use of that language is a reminder to the majority again that your language is not good enough, you are not good enough.
Now that you've listened to some of these reactions, I would want to bring in another dimension to this discussion. For example, the construction of a record, which is very much informed by the languages of record, as we know. Of course, we are now in a situation where we have one language of record, which is sort of dictating how statements are to be constructed. Initially, we had two, like English and Afrikaans, but now we have now opted for one, as per the directive of the Chief Justice. Now, linked to that dimension, there is a whole question of access to justice, which is one of the important implications that I made reference to earlier. And I would like to make a case about the veracity of the statement itself when it comes to the legal process. Why is the statement important? I think that is a very important question. Why is it particularly important when it comes to the administration of justice? I think we need to answer that question in order to understand the complexity around, the language of record and the language in justice. Now, a statement itself, from the background that I'm very much aware of, is a story that forms the basis for the legal process. It could be seen or perceived as an entry point through which evidence is driven. I think more importantly, one could look at it as an anatomy that provides the trajectory of the inquiry itself. Now, by so suggesting, you're referring to it as, leading the charge itself, or alerting us about the circumstances surrounding the crime. Or maybe you could look at it as a way of establishing the credibility of the evidence. It's got all sorts of very important components that you can think of, including those that I've cited. Now, more critically now, you could look at it as a protector and a preserver of the originality of the story. We normally talk about the verbatim, narrative. That's where it comes in. It gives an account of the circumstances surrounding the crime. There are various spin-offs if statement or a sworn statement or a legal text, if you like, is perceived from the point of view of being a preserver and a protector of the originality of, the crime or the narrative, as it were. It could also serve as a reminder or as a refresher, if you like, of those who are involved in a criminal activity. It could be a witness, it could be an accused person, it could be a complainant. we could think of it as a reminder that assists the presiding officer and his or her team in handling the case, about the legal agenda of the day. So in other words, it's very crucial for the primary audience, which is the court, to keep going back about the turn of events as they were. You could use it as a verifier, in terms of accuracy and consistency, as the statement was used to capture, the content of what happened before the matter is brought to court. Now it becomes a very important base, for court proceedings. You could also think of it as a triangulator, if I may use that word, in terms of evidence as and when the need arises. So the presiding officer could use it to fall back on where there are grave misgivings in terms of the facts. So you can learn from that it is a very important component in terms of the administration of justice. But the bigger question is whether it is used, following the very same pattern in South Africa to capture evidence the way it's supposed to capture evidence. Unfortunately, with our complex situation of so many languages, it's difficult to say, because some of the languages that we have provided in the Constitution do not count. And a statement does relate to that, because the legal text has to be presented in English, not in any other language. And for that reason, it means it does not protect or preserve the originality of the narrative. That's what it means. So if the statement fails to do that, now the consequences are adversarial. And we've seen some cases where this is the case. And I think the observation, as it stems from the pronouncement by the Chief Justice, spells out how problematic the legal process can be if we end up with a single language that could be given recognition as a language of record. If we agree, which I think we should, that a legal process is partly a linguistic matter, I think we need to take diversity seriously. And if we do take diversity seriously, we have to at least create space for multilingualism within the criminal justice system. It should not just be, a situation where we then look at it as window dressing. It should be multilingualism in action. It should be functional, and we should create space that other languages are given full recognition in terms of handling legal matters. It is a constitutional imperative, there's no doubt about it. I think we all agree that the Constitution itself is not self-executing, but you need people to drive it, and people who know more about driving these matters. So the question of language and justice is still an issue that needs, serious attention in South Africa today. Otherwise, if we don't look at it very carefully, we are back where we were before 1994. Thank you very much.
Thank you very much, Professor Kgalagala. Also some important points raised there to take the discussion forward. And now to sort of summarize what's been discussed by the first two speakers, and obviously to offer some insights of her own, our third and final speaker for today, Dr. Zakira Dokrat. All yours.
Natasha, Justice Krichler, Prof. Khalakhala, Dr. Mortignane, and colleagues. Molweni, Dumelang, Goeiemorgen, good morning. It is an honor to be part of this language and justice seminar today. I will be offering a response to Prof. Khalakhala and Justice Krichler's presentations. In doing so, I wish to raise further points of discussion. While listening to the presentations, I was reminded of the 2018 judgment in the case of State versus Gordon, in which the court had the following to say, open quote, "Academics have the intellectual integrity and the moral courage to argue about what the language of record should be in our courts." Open bracket. The role of African languages in the South African legal system towards a transformative agenda. A thesis submitted in fulfillment of the requirements for the degree of Master of Arts, Rhodes University by Zakira Dokrat, November 2017. Close bracket. They can afford to argue about the law. Judges do not have the luxury to argue about what the law should be. They have a constitutional obligation to apply the law. The nation expects judges to resolve disputes expeditiously in a manner that is user-friendly, practical, and cost-effective. Close quote. For this seminar, we have a presentation by an academic, Prof. Khalakhala, and by a judge, Justice Krichler, and interestingly, Justice Krichler provides his disclaimer of advancing his opinions from a point of practice. The starting point is, of course, the Constitution. Section 6 is our linguistic blueprint, social contract between the state and citizens. It informs the rights housed in the Bill of Rights, which includes Section 35 of the Constitution, specifically Section 35(3)(k), affording a language right to accused persons. Section 6(2) obligates the state to take practical and positive measures to elevate the status and advance the use of the 9 indigenous languages. Having said this, the English-only Language of Record Directive by the heads of court under the chairmanship of the Chief Justice, in my opinion, undermines this provision and instead elevates English to a super-official language at the expense of the African languages. We have moved from a bilingual language of record policy to a monolingual policy on the basis of equity, transformation, inclusivity, and justice for all. I totally disagree. To my mind, this is untransformative and unfair and creates a different standard of justice for African language speakers who do not have access to English. As I progress, I will explain why I think it is unfair and untransformative. Before I progress with my reasons, it is important to note that the Constitution is merely a framework, as pointed out by both presenters. The discretionary language in the form of words and terms used in the language rights provisions such as may, where practicable, taking into account usage and expenses and so forth, are currently being used as defense mechanisms for failing to give practical meaning to Section 6 and the use, promotion and development of African languages in high-status domains such as the legal system. Instead, there is a convenient lapse in memory and oversight of the built-in constitutional guidelines of equity, historical redress, of past marginalization, and so forth. Section 35(3)(k) is the primary right in concern for this seminar, as pointed out by Justice Krichler. By having an English-only language of record policy, we are immediately creating a system in which English is the yardstick. An African language or Afrikaans-speaking accused who cannot understand English is immediately conferred with an interpretational right, while an English-speaking accused will always have a language right. How are we saying this is fair, and what the constitutional drafters intended to happen? Having said this, there are 6 points I would like to discuss very briefly given the time constraints. These include 1. Interpreters, interpretation, forensic linguists. 2. Judgments and appeals. 3. Language requirements, linguistic training for legal practitioners and SAPS officers. 4. Legislation and policies. 5. Basic education, higher education, textbooks. 6. Language policies per province. Only 9.6% of the population speak English as their mother tongue. When we look at the surveys conducted by Legal Aid South Africa, by my colleague Annelies de Vries and I, there is a clear indication that the majority of our litigants across provinces do not speak, read, write, nor understand English. Similarly, in our voluntary survey conducted with 2,500 practicing attorneys across South Africa, we found that the majority felt compelled to communicate in English with their clients even though it was not their mother tongue, as it would prepare the client for an English-only courtroom. The majority of persons are thus reliant on interpretational services in courts. I know of many highly qualified and competent interpreters who do a fantastic job in our courts. It is, however, unfortunate that these interpreters are in the minority. We have seen many high-profile cases exposing poor quality interpretation in courts. The interpretation profession is not regulated. There is no standard legal and linguistic training for interpreters that forensic linguists could offer. Interpreters are understaffed, are subjected to poor working conditions and a lack of resources. We are to proceed with an English-only language policy, then we are to have more resources, regulation, qualifications, training, and an overall haul of the system. Secondly, the issue of judgments and appeals where languages other than English are used appear to be raised. Let me remind you all that the recent judgment written by Judge President of the SCA, Judge Mandisa Maya, in the UNISA language policy case was bilingually written, with the English and Afrikaans language text appearing alongside each other. This was most welcomed and proved that our African languages have the capacity to be used in high-status domains and are being intellectualized, where terminology is available. Secondly, this follows the model of Canada, specifically the province of New Brunswick, where judgments are produced bilingually where necessary and translated for appeal and review processes to ensure judicial officers are not excluded or shopped for on the basis of language. This also creates further scope for employment of legal and linguistically trained translators or forensic linguists to act as translators in courts. We also have cases in South Africa that have successfully proceeded in an African language, with all parties to court competent in that language. These include State v. Damoy, State v. Matomela, and State v. Damani. Thirdly, there is an obvious need to ensure our legal practitioners and judicial officers are not only competent in English, but also in at least one African language or Afrikaans to give effective meaning to our language demographics. I am well aware that we cannot wake up tomorrow morning or next week or next year and have all legal professionals competent in a language other than English. But this does need to happen. It is possible, as we have seen in Canada and Belgium. The SAPs have a critical role to play in courtroom discourse, as highlighted by Prof. Khalakhala, through statement construction. Linguistic training for SAPs officers is needed. There is no reason why we cannot employ translators and interpreters to assist in police stations to ensure statements and oral narratives are accurately recorded. This speaks to employment creation. We saw in the case of State v. Omotoso the stark disparities between Cheryl Zondi's written testimony constructed by a police officer in English and her oral testimony. It places African language speakers at a disadvantage in our courts, where witnesses' credibility is being assessed. We need to be careful of being on this path, as the case of Australia and the Aboriginal people have proved that the use of language is powerful and can be used to disadvantage Indigenous speakers. This leads us to the fourth point of discussion, namely legislation and policies. There was a proposal in 2017 by the Parliamentary Portfolio Committee for Justice and Correctional Services that all LLB graduates learn an African language before graduating. As with most initiatives, it was unfortunately not pursued. It is therefore very concerning and disturbing that legislation such as the Legal Practice Act, aimed at the transformation of the legal system, does not include language, nor refer to language or language requirements and training. It really makes me wonder what the understanding of transformation really is. The same thing appears to be happening with language policies. For instance, the language policy of the Department of Justice and Constitutional Development merely refers to the legislative provisions for the language of record and proceedings, knowing very well that the said legislation does not make any provision for the use of African languages as languages of proceedings and records in court. Fifthly, it is not only the responsibility of the Department of Justice, the heads of court, and the Chief Justice to linguistically transform the legal system. What is needed is an entire overhaul. We cannot expect to have African languages as languages of proceedings and record where we do not have legal practitioners and judges who are not competent in these languages. This speaks to the need for basic education in universities to ensure that our graduates are linguistically competent in a language other than English before graduating. Academics and researchers have a responsibility in terms of the constitutional mandate to ensure textbooks are written in the African languages, to ensure material is available and in turn intellectualize these languages. It is only at this stage where we have all sectors working together, where we can begin effective change and transformation, where we have language policies for courts drafted per province, taking into account the language demographics of the provinces. Again, this is not a foreign concept. It is being achieved in other countries, and we have models that we can adapt and emulate. Our legislation needs to be accessible in all our official languages, even if this is to occur on a rotational basis. The current case by attorney and language rights activist Cornelius Lawrence, pending before the UN, addressing the issue will be of prime importance in shaping our future. The Chief Justice, heads of courts, various ministries, and government as a whole have a collective responsibility to ensure language policy and directives are drafted fairly through a consultative process, taking into account the extensive research that we conduct, the views of the legal profession as a whole, as well as, most importantly, including citizens who are accessing courts in the pursuit of obtaining justice. We have problematized the language issue in our legal systems, where the African languages are undermined in status and use and are not seen as a right and a resource. We continue to talk about the issues and what needs to be done. We are now at the stage of actually implementing our changes, and this requires individuals who are willing to serve the needs and rights of persons who do not benefit from an English-only language of record policy, who do not have access to English, the very people the Constitution seeks to protect. Thank you.
Thank you very much, everybody. I think some really important points raised by all of the speakers there, and greetings to you all from a very rainy Cape Town. I'm sure I'm not the only one of the more than 60 participants I see on here who are in the Cape today, so I hope everybody's keeping warm. Just a couple of things. First of all, to say that we're delighted to be joined on this webinar by Ms. Preetha Dabadine, Hansard's Board Deputy Chair. Thank you very much for making time to join us today for this important discussion. Also, I see lots of people are already making use of the little Q&A button that you'll see along the bottom of your Zoom screen. If you'd like to add any questions in there. You can also WhatsApp questions. Please don't call, WhatsApp only, to 082 613 2765. That's 082 613 2765. We'll do our best to get through all of the questions. If there's anyone you'd specifically like to direct your questions or comments at, please do add that to the WhatsApp or to the little Q&A section so that we can direct them accordingly. We've got limited time, excuse me, before we move on to the summation, so we'll do our level best to get through people's questions. If questions haven't been answered, I've been assured by the organizers that these will be answered via email afterwards. So just to start off with, again, to say thank you to the speakers for their presentations. A question here from Hantibale Nadoba, forgive me, mispronouncing your name, particularly on a discussion about Indigenous languages. So this is directed at Justice Krichler. Is the constitutional provision of South Africa of 11, or shall we say 12, with sign language, official languages, not political speak or political correctness, as opposed to linguistic justice, for lack of a better concept? The Constitution has what is called escape phrases or clauses, such as where practically possible or where practicable. This goes to show that the Constitution is couched in a language that basically portrays English as both de facto and de jure language, the so-called language of record of the courts. Why is this so? I put it to the judge that South Africa is not legislatively multilingual, but still bilingual, because we still have law reports in Afrikaans and, of course, English. We are lost in linguistic politics. Justice Krechler, would you care to comment?
Of course, the language provision was an uncomfortable compromise at the time, both of Cadessa and then finally in the drafting of the final constitution. It is a difficult problem. We have not solved it. We're not going to solve it this morning. There are only 2 languages of sufficient technical capacity to write the statutes of the laws of South Africa. Those are, unfortunately, for historical and neo-colonial reasons, English and Afrikaans. I don't like it. Nobody likes it, apparently. It's non-transformative. It happens to be a fact of the day. We cannot hope to resolve that problem by an introduction of a totally impracticable regime in court. No textbook exists in any of the indigenous languages in which you could train prosecutors or defense attorneys to conduct cases in any of the indigenous languages. The statutes don't exist. The textbooks don't exist. The law reports don't exist. And may I just say very briefly in response to Dr. Docrat, I know the Constitution as well as she does. Section 35, 3K says nothing about mother tongue at all. It's.
I think perhaps we've lost the Justice Krechler just for the moment. Perhaps just for the interests of time, I'll move things forward and we can come to wrapping that up. I'm just going to, if you see me glancing away, it's because I'm looking at the Q&A section. Professor Kgalagala, perhaps I can direct this at you. It's from Justin Basude. Whilst respecting the recognized languages in our constitution, including sign language, the question of record keeping is the issue, and I do believe that enough discussion has taken place around that, including a directive from the Office of the Chief Justice. Secondly, I have a concern about the availability of sufficiently qualified interpreters and their ability to interpret legal jargon accurately. The impact of outcomes of cases can be compromised. I know that both you and Dr. Docrat have dealt with this in your research. Should we not also be looking at the use of technology as a means of allowing judicial and other officers to follow matters? There are many creative apps available. Prof. Kgalagala?
Thank you very much, and I really appreciate the opportunity. I must also acknowledge both the judge and Dr. Docrat, wonderful presentations, and colleagues, and those who are participating in this session. Thank you. Going back to the question, I think the Australians are advancing in terms of leveraging on technology when it comes to record construction, which is an important step. I mean, as we are confronted with technology itself and possible the 4th industrial revolution on our shores. What we have recommended, because you will also appreciate if you follow these events, that the issue of police talk and record construction is the most problematic in South Africa today, as is considered to be an important aspect in the administration of justice. And therefore, leveraging on technology is one important recommendation that we're putting forward. It has all sorts of spin-offs. The one that I've made reference to, it becomes the preserver and the protector of the originality of the narrative itself. You will also understand that if we take statements, sworn statements in particular, the process is divided into 2. you have the first layer, which is the pre-statement session, mostly characterized by intra-linguistic translation. Now, the second layer would entail interlinguistic translation. And it is at that point that we feel strongly that, technology should take its course. Because if you record it, that is the original statement, the verbatim statement, you should be able to fall back on should there be misgivings in terms of the facts. At this point in South Africa, these statements are taken by hand. It's pen and paper. And the risk surrounding that is huge. So basically, if we were to look at technology and put it to good use, it might serve a very good purpose in that we will not be looking at one particular language. We could also be looking at other languages because we will be using that record, and it is through that record that we would then be in a position to employ or look at possible translators who could bring about quality work to do the translation as and when necessary. So I fully agree that technology could save us as we forge ahead with this. I'm very worried about the slogans that keep coming back about things not being possible or things not being practical, even before we can put them, to test. I think it's sort of worrying if we go in that direction. Thank you very much.
Thank you very much, Prof. Kgalagala. Welcome back, Justice Krikler. Sorry to hear you're having connectivity issues. Prof. Kgalagala, don't go away because the next question will be for you as well. So this comes from Dr. Munir Abdurov from the CRL Rights Commission. It's addressed both to yourself, Professor, and to Dr. Docrat. So perhaps you can kick us off and then Dr. Docrat can come in after you. Can you advise your view concerning which languages should be used, or if all should be used? And how do you advise that we use all the languages in a practical way based on the issues that Justice Krikler has referred to?
Okay, thank you very much again. Can I also make a statement that languages are more like living things? They develop day by day, week by week, month by month in terms of handling advancements. We could be talking about technological advancements, we could be talking about legal advancement, and so on. The speakers of these languages should also take upon themselves, it has to be a high level of commitment to see to the development of these languages in order for these languages to handle any phenomena that we can think of. So it cannot be right to say one or two languages have the capacity to do this. Yes, I agree. At this point in time, we may not be ready, but given the opportunity, especially understanding that the Constitution does provide for these languages, it should not be a case of narrative anymore or slogans. There should be practical ways and means to do this. One practical step, which I think Dr. Doctract has cited, is about us looking at basic education as well as higher education. That's where it should start as part of developing, capacity in terms of the languages itself, to be in a position to handle legal phenomena if we're talking about the criminal justice in this case, which is the case. So I would want to look at the curriculum, the way it's designed. We need to take a closer look and review the curriculum. We can't keep on saying, yes, it is there, and we don't seem to begin to think about any innovation or rethinking of the curriculum in order to cater for what we look at as inclusivity, we look at as transformation, and all sorts of, equitable means of addressing the deficits of the past. So my point is the curriculum is a starting point. But again, beyond the curriculum, we also need to look at the people who are leading in this, our judges, our legal minds. I think we need to change our attitude. We can't begin to think of these situations as impossible without even try. I mean, we've highlighted cases. I remember not so long ago, some bit of resistance came through in one of the trials where one of the members, I think it was a lawyer in this particular case, wanted to address the court in isiZulu. And it created a stir because there was no room created for this. No one was keen to listen. So my point is, there has to be a platform that is being created. The attitude should change. We need to put these things to test before we begin to make, statements that they are impossible. The Afrikaans language started so well with all the capacity required to address issues in the, domains like government, you can think of basic education, higher education, and so on and so on. Now we see a situation where it is being shut down, and it creates more problems for other languages which are still in the periphery. So my assumption is that we need to create space, and the speakers of these languages should also be in the swing of developing the languages in order to address these phenomena. Thank you.
Very much, Professor. Sorry, just kicking my video off again. So we're fast running towards the summation. So Dr. Docrat, perhaps I can come to you next with a different question and then just wrap up with a question for Justice Krechler before we pass on for the summation. Thank you all for your questions. I'm sorry that we haven't had time to answer all of them. Lots of good points being raised by people around the issue of language. Language is being viewed as resources. I guess to the point that Prof. Khalkhal has made about languages as living things, so resources that need to really be developed. And then I'd just like to direct at you, Dr. Docrat. Professor Russell Kashula from Rhodes asks, why are we obsessed with one-size-fits-all language policies? Can policies not be localized and then effectively implemented?
Thanks, Prof. Kashila, for that question. I think it ties in also with the previous question. If we look at certain provinces, in my opinion, there's no reason why we can't try and pilot per province. There is the issue of, in Gauteng, for instance, as Justice Krechler raised, more than one language spoken. And how do we do it in those instances? That will be tricky, but I still think that provincial language policies can work. We know that in the Eastern Cape, in the former Transkei, there have been pilot projects run where we have used isiXhosa as a language of record and proceedings, and that has had its challenges. But as I've said in my presentation, I think the challenges can be worked on. I think it's an issue of practicality. And if we are willing to plow the resources into the development of our languages and actually using them as languages of record in our courts, then we can develop these language policies per province. As I already said, there are models that we can emulate. South Africa is a tricky one because we have 11 official languages. So it won't be about using all 11 official languages in one court, say for instance here in the Grahamstown High Court. That obviously would be impractical. But why would it not be practical to use isiXhosa, English and Afrikaans, which are the majority spoken languages in the province, as the languages of record, and then use the judges on a rotational basis and how we see fit. But I think it is possible to do it. I think it's a matter of whether we want to do it. And currently my opinion is that there is no buy-in from government and from the judiciary as a whole to support this view of thinking. Thank you, Natasha.
Thank you very much. Dr. Docrat. So as I say, I'm very sorry, but we're running out of time. So Justice Crickler, if we can just direct a last question at you. This is from Annelies de Vries, who, if I'm not mistaken, is at the University of Johannesburg. Annelies, I'm sorry if I've got your title wrong from the back of my head. Justice, what is your opinion about the proposed language policy of the Legal Practice Council?
I have no comment on it. I'm not a member, I'm not an expert on that particular field. I believe, however, that it is inevitable that legal practice, legal language of interaction between practitioners in court and outside court will be in English, unavoidably, undesirably, and for the foreseeable future.
And again, thank you everybody for your questions which have come through. I know not all of them have been answered, and I apologize for that, but time is not on our side. And thank you again to the panelists who've taken part today. Again, Justice Crickler, it's been a pleasure to have you here. Prof. Monwabisi Kgalagala, thank you very much, and Dr. Zakira Docrat, and thank you again for the introduction, Professor Ramani, whom we'll be hearing from again shortly. And just to say that questions that haven't been answered, ILAF has said that they will seek to answer via email. So hopefully we can continue engaging around these issues, because I think, as all of the discussants have said, none of these issues are going away anytime soon. Now it's my great pleasure to thank you all for being here and to hand over for summation to Dr. Mantoa Motinyane, who is UCT's Head of African Languages in the School of Languages and Literature, and who specializes in, if I'm not mistaken, African linguistics. Over to you.
Professor Kgalagala, Dr. Docrat, Dr. Mali, Professor Ramani, Natasha Joseph, and fellow colleagues. Ke a le dumedisa. Dumelang. Molweni, Lochani, Sanibona, Thobela, Macheloni, Goeiemorgen, good morning. My name is Mantoa Motinyane. I am currently based at the University of Cape Town. I will, however, be joining the University of the Western Cape as an associate professor in linguistics starting in January 2021. It is indeed an honor to participate in a discussion organized by the Indigenous Languages Action Forum in partnership with the Western Cape and South in celebration of the 2020 International Translation Day. It is also a great honor and privilege to be part of a discussion since yesterday South Africans celebrated Heritage Day, where we celebrated the cultural wealth of our country, which by default includes language. Part of the motivation for the celebration of heritage in South Africa stems from the fact that the Constitution of South Africa enshrined and guaranteed the right of use of our languages in the Republic of South Africa. As indicated by Dr. Mali in her welcome, language practitioners find words for a world in crisis. Part of what we are doing today is to propel this agenda. Since 1994, we have been debating how this right to use one's language can be implemented in schools as medium of instruction, in the legal system, for official communication with other government departments in order to access services. This is just to mention a few examples. 26 years later, we are sitting with the same questions where we are asking about what role language can play in the judiciary system. Today we are discussing two questions which I have collapsed, three questions in fact, which I have collapsed into two. The first question is, what are the benefits or disadvantages or negative consequences of using English or indigenous languages as the languages of record and proceedings in the criminal justice system? The second question is the use of indigenous languages in the criminal justice system at all practical or practicable? How might one make multilingualism work in this sector? Our discussants, Justice Krichler and Professor Khala, presented their views on these questions. One in support of English as the language of record in the criminal justice system, and the other supporting multilingualism. Our respondent, Dr. Doctorate, also supported the adoption of a multilingual policy for record keeping. I will now provide highlights of the two presentations and then a summary of the response by Dr. Docrat. Justice Krechler agrees on one hand that the linguistic and cultural rights of the minorities are protected by the Constitution of South Africa. He further points out that this includes the right to use language of choice in all interactions with the state, including recordings and proceedings of the court. On the other hand, he argues that the judiciary system created laws predominantly in English, for example, textbooks are in English, and even discussions amongst the various stakeholders, such as the legal representatives, the prosecution, the defense, all require proficiency in English, which will allow them to engage in dialogue. This dialogue, he argues, the legal representative needs to be highly competent, for example, in order to communicate with his clients. Justice further argued that it is very rare to find a court sitting where all stakeholders share the same indigenous language. So in summary, he points out that the use of English provides the practicality, functionality, and necessity that the indigenous languages cannot provide. It is important to note, however, that in his closing remarks, he mentioned that Afrikaans was a highly developed language which was able to function as a language of record in the justice system, and expressed sadness over the choice of English as the only language of record. Professor Khala presented a bottom-up approach to the debate. He pointed out that the pronouncement of English as the only language of record within the justice system has also impacted on other areas of life. He further points out that whereas the Constitution of South Africa promotes the use of all official languages, such pronouncements as those made by Chief Justice are saying, your language is not good enough. According to Prof. Khala, the statement which is recorded by the police officer is the most important component of the administration of justice, and accordingly, the justice system needs to preserve and protect the originality of the statement, as this is the base for verifying accuracy and consistency. He argues that in the light of the English-only policy for the judiciary system, the credibility of a statement that has been interpreted is highly questionable. Given that the legal system is a linguistic matter, he argues that the justice system needs to create space for multilingualism. Dr. Docrat, in her response to the two presentations, takes the discussion further by pointing out that the English-only approach undermines the provision of the official languages in the Constitution of South Africa. And as such, she finds it to be an unfair practice, as it provides speakers of English direct access to the justice system, while speakers of other languages have interpreted access to the system. This she finds highly unfair, as the interpreters currently provided by the courts, with the exception of the few, are unregulated, highly unqualified, and untrained. Rather than focusing on advantages and disadvantages, Dr. Docrat responds to the second question of the discussion by providing possible and practical steps that can be taken to push the transformation of the legal system. She argues that this should not happen in isolation, but rather proposes for an entire overhaul of the system where the judicial officials and legal practitioners need to be competent in at least one indigenous language in addition to English. A system where interpreters will be trained, regulated, and qualified, where legislation and policies will be put in place to ensure that all graduates are competent in one other language in addition to English. In closing, she argues that putting such measures in place will make legislation accessible to all citizens of South Africa. In closing, it does seem like we need to ask some of the questions differently. So rather than asking about the benefits of English as a language of records in the justice system, we should be spending extra time and energy on finding ways in which we can put our heads together to protect the constitutional right to use one's language. I do believe, however, that platforms like this, where we bring different stakeholders together, is a step in the right direction. And for that, I would like to thank the organizers of this webinar for making the space for such engagements possible. Ke a leboha. Thank you.
Hello, everyone. Well, I just have to say a couple of things about ELAF, and thank you everyone for the discussion. And I just need to say a little bit more about ELAF, the kinds of things we do, apart from holding webinars such as this one, which is really a matter of putting across and sharing different points of view and educating the public in general about what the issues are around the gap between policies, our constitution, and practice. Another very important role we play is to act as a pressure group on various language bodies and on government to make the policies about equity of languages real in various ways. And finally, resource sharing. So if you go to the ELAF website, you will find many resources in the different indigenous languages around basic education, around literacy, and more recently around information surrounding the COVID epidemic. So you can learn more about us at our website and also on our Facebook page. And sometime during the course of the coming week, the recording of this webinar on language and the justice system will be replayed for those who missed it and would like to see it. Thank you so much.
Thank you all again for joining us today. Enjoy the rest of your Heritage Month, the few days that are left of September. We hope everybody stays safe and well out there. Thank you so much for joining us today, and thank you very much for hosting us, Prof. Ramani, and to the Pan-South African Languages Board of the Western Cape, and to all of you. Thank you for making this a really robust discussion. We're looking forward to many more engagements like this. Go well.